All right, guys, moving on. FAR bar as is 5, section 13. This is talking about the escrow agent and the broker. All right. So just remember here that I have a note up here that agent in this paragraph references the escrow agent. So when it says agent here, it's not the real estate agent, it's the escrow agent. Now, a lot of times what we're doing is that is usually a title company or an attorney's office that is acting as a title company. So there's some just things to be aware of here. All right. A couple things I just noted. It says they're going to collect the deposit. Other funds, they're going to hold them independently and hold the same in escrow with the state of Florida, subject to collection. You're going to disperse them in accordance with the terms and conditions of this contract. I'm going to talk about that at the end for a second, but let's just go here. One highlighted thing I hear: failure of funds to become collected should not excuse buyer's performance. So that means it doesn't cancel. The buyer can't just say, well, I didn't deliver the escrow, so we no longer have a contract. Now, it could be something that a seller can insist upon in order to say the buyer's in default, but just non-delivery. And when the buyer's in default, then there are remedies that the seller has when a buyer defaults on the contract, but it does not void the contract. We've checked up to the FAR legal hotline and everybody else, and it needs to be there. We need to verify that the money's there and it needs to be in, but it does not require it to be in to be a valid contract. When conflicting demands for the deposit received or agent, that's the escrow agent, has a good faith doubt as into the entitlement deposit, agent may take such actions as by this paragraph. You can read through this. This basically talks about when and who can release the money. Now, here is the reality, all right? I'm a firm believer that the contract is clear on a couple of major things. Number one is if it's an as-is contract like the one we're going through right now, then the contract is clear that the buyer at their sole discretion can cancel the contract. We went over that in section 12 about it being a get out of jail free card, right, for the buyer. If the buyer timely delivers notice that they are electing to cancel the contract based upon the inspection period, then it is my opinion that the escrow agent should release that money to the buyer and cancel the contract, regardless if the seller will sign off on it or not. What we're seeing a lot of right now is that sellers are holding earnest money hostage when they should not. When it's clear in the contract, the money goes back to the buyer. That either in our case, as we learned under the financing clause in paragraph 8, that they delivered their notice that during the loan approval period, they were not able to get loan approval, and it happened in the timely manner during that period, then the contract is canceled and the money goes back to the buyer. Same thing with the inspection period. Usually it's 10 or 15 days, but if that's done, then the money goes back to the buyer. The contract is very clear on this. But there are many escrow agents who will not release the money to the buyer because the seller refuses to sign off on it. Now, a couple things. If the seller refuses to sign off on it, note that the contract is not canceled, and even though the buyer wants to cancel the contract, the seller should not, and the listing agent should not put the house back on the market as active until the closing date, which is usually sometimes 30 or 40 days out from that date, comes and goes. So that's one bit of leverage a buyer's agent can have. The other bit of leverage is that the contract is clear, and if the buyer has to hire legal counsel to try and get their money back, not only will they get awarded their money back, but they have the right to get the seller or the non-prevailing party to pay their legal fees as well. So just be aware of that. Now, I have run across an attorney-owned title company that is agreeing that in any proceeding between the buyer and seller where an agent is made a party because of acting as an agent hereunder, by the way, that's talking about the escrow agent, the agent has the right to recover reasonable fees out of the escrowed funds in order to protect themselves if they get sued as a result of this. All right. However, I have run across a title agent who is an attorney-owned title company that is agreeing that if the contract is clear and they've done an investigation, the contract is clear, like say the instances I've created, or in the reverse situation, the buyer just backs out and cancels at the last minute and they're already past the loan approval period, then it's clear that the seller gets the money. and they may release the money to the seller. The only way, and this is what this attorney was pointing out to me, the only way that he can get sued is the agent shall not be liable to any party or person for misdelivery of any escrowed items, meaning he gave it to the buyer or the seller, without all parties agreeing, unless such misdelivery is due to agent's willful breach of the contract or agent's gross negligence. That means they would have to prove that or the attorney or she, whoever released the money without the other party's signature, did it willfully breaching the contract, like there was nothing in the contract that allowed him to do that, or they were just grossly negligent, which is a really tough case to prove. So this guy says he's willing, if he holds our earnest money and does the closings, to release the money when it's perfectly clear. By the way, if you represent the seller in a case and they want to not sign off and hold off on this money and the buyer is canceling in their predetermined time frames, I will tell the seller, even though we as Future Home Realty represent them, that they're wrong and that they need to release the money because they've already agreed to in the terms of the contract. So talks about earnest money. Just a couple things. Main things are that get the money in, but failure of it to not be collected does not excuse the buyer from their performance under the contract. They can't just not deliver it and say, I changed my mind. And then realize that there are some title companies out there who will release the funds. Normally, though, you're going to run across people that say, I'm not going to release it unless all parties do it. The key point there is that the seller cannot reactivate the property on the market even though the buyer has indicated they want to cancel, unless the seller has agreed to cancel and signed a cancellation agreement, and all parties have agreed how the earnest money is to be distributed. And we do that through a release and cancellation amendment to the contract, which is available on our forms as well. Hope this settles up for Section 13. Have a great day.